Good morning and welcome to this webinar, which is organised by the European Lawyers Foundation, ELF, and the Council of Bars and Law Societies of Europe, CCBE, in cooperation with the European Union Intellectual Property Office, EUIPO. The topic this morning is intellectual property enforcement for generalist lawyers in the EU. My name is Jonathan Goldsmith, Senior Project Counsel with the ELF. This webinar is taking place within the framework of an EU-funded project called TRAVAR, which is the short name for a project which covers training of lawyers in various areas of EU law. We have a lot of people joining us this morning, and so while people are entering the webinar, I will make a number of important announcements. Number one, questions. We encourage questions from all participants. We ask the questions to be put in the question and answer box. Questions will be answered if time allows it at the end of each session or otherwise at the end of the webinar. Please don't use the chat for the questions. Use the chat to say hello and tell us where you're from, but put questions for the speakers in the Q&A box. We prefer questions in English if possible, but we can cope if they're in French and Spanish. This webinar is being recorded, and the recording will be available later today or tomorrow on the ELF's website. The webinar is in English, but there is interpretation into French and Spanish. Please use the interpretation button at the bottom of your screen if you wish to hear the webinar in either French or Spanish. And two very important points. Often we get questions from participants saying, will they have access to the slides which the speakers will show? Yes, the slides will all be uploaded onto the ELF's website. I have seen the presentations. They're packed with extremely useful information. And if our speakers today don't have the time to go through every detail, you can consult the slides on the ELF websites later. 2, if you are looking for a certificate for continuing legal education, we do not provide the certificates. You need to approach your bar, and if you need any credits, if it's not a certificate, if it's a credit, we provide your bar with a list of members who have participated, together with your connection time for those bars who requested. So don't ask us for the certificates, approach your bar and they will approach us. Now we will begin the webinar. It's my great pleasure to introduce two welcoming speakers. Our first speaker is the first Vice President of the Council of Bars and Law Societies of Europe, Roman Zabashek, who will make some introductory remarks. Roman was president of the Slovenian bar from 2012 to 2021 and has been actively involved in CCBE work for many years after becoming head of the Slovenian delegation to the CCBE in 2012 and chair of its committee which looks after bars in the east of the EU since 2020. He's a graduate of the Faculty of Law of the University of Ljubljana and a managing partner of his law firm. So, Roman, over to you, please.
Thank you very much, Jonathan, for your kind words. So I firstly apologize for my broken voice, but the illness never comes into the right moment, but it's going to improve in a couple of days. So welcome also from my side. So welcome, distinguished guests, dear Miss Patricia Garcia Escudero, esteemed colleagues. It is my pleasure to welcome all speakers and many participants joining us today for this important webinar dedicated to intellectual property rights. Your presence reflects a shared commitment to advancing knowledge and expertise in this vital field. Given the number of new faces in attendance, allow me to briefly introduce the Council of Bars and Law Society of Europe, the so-called CCBE. The CCBE stands as the unified voice of the European legal profession, representing over 1 million lawyers across 46 countries. Our core mission centers on defending the rule of law, upholding human rights, and promoting democratic values throughout Europe. We advocate for the collective interest of European bars and law societies before European and international institutions, serving as a bridge between our members and key organizations worldwide. Our work is driven by expert committees, and I encourage you to visit our website for further details on our ongoing initiatives. The CCB is deeply committed to the continuous development of professional knowledge and skills among lawyers and legal professionals. We believe that regular training is essential to maintaining the quality of justice across Europe. Training in EU law and cross-border issues is particularly crucial for ensuring the coherent application of EU law and fostering mutual trust in judicial proceedings. This commitment is enshrined in the CCB Code of Conduct, Article 5.8 on continuing professional development, which states, lawyers should maintain and develop their professional knowledge and skills, taking proper account of the European dimension of their profession. Our training committee actively monitors and analyzes policy developments at both national and EU levels, focusing on judicial training and professional qualification for lawyers. In 2023, following several productive meetings, the CCB signed a Memorandum of Understanding with the Observatory of the EU Intellectual Property Office, establishing key areas of cooperation. Today, I am delighted to witness these fruits of this partnership. Our second joint webinar for lawyers on intellectual property enforcement, organized in collaboration with CCBE, the European Lawyers Foundation, and EUIPO Observatory. The inaugural webinar was held in March 2024. As part of today's program, you will be introduced to the EUIPO brochure for generalist lawyers in the EU, which provides essential information on intellectual property and IP rights enforcement. CCB experts contributed to this valuable resource, and I trust it will serve as a helpful guide for all. I would also like to extend my gratitude to the ELF for their unwavering support in organizing this event, which is held under the auspices of our joint TRAVAR project, financially supported by the European Commission Justice Programme. Several webinars covering diverse topics will be organized for lawyers as part of this initiative. In conclusion, I'm confident that our continued collaboration will not only enhance the professional capabilities of lawyers across Europe, but also strengthen the integrity and effectiveness of our shared legal system. Thank you all for your dedication and commitment to advancing the standards of legal profession, and I wish you today a very interesting webinar. Thank you.
Thank you, Roman, and thank you in particular for coming from your sick bed to welcome us all. We appreciate it, and we wish you the best recovery. Our second welcoming speaker is Patricia Garcia Escudero, who's a director at the European Observatory on Infringements of Intellectual Property Rights at EUIPO. She's been with EUIPO since 2019. Before joining, she was Director General of the Spanish Patent and Trademark Office. At international level, she's been chair of the Management Board of EUIPO, member of the Administrative Council of the European Patent Office, and a delegate in the assemblies of the World Intellectual Property Organization, EUIPO, representing Spain. Patricia, please.
Thank you, John. First of all, I would like to welcome you to this second webinar on intellectual property enforcement for generalist lawyers in the EU. As you have already said, this webinar is jointly organized by the IPO, the CCBE, and the ELF. And also, as Roman said, this training builds on the success of our first joint event last year in March, which was attended from more than 750 lawyers. That confirmed the importance and the demand for practical and accessible training in this area. Strengthening the expertise of professionals involved in the enforcement of intellectual property rights remain a high priority for the EUIPO and the Observatory. In fact, it is a core objective under the Strategic Plan 2030 adopted at the end of last year, under the goal building trust and respect for intellectual property. An intellectual property right that cannot be properly enforced brings little value, neither to its owner nor to the society. That is why it's crucial that all stakeholders in the enforcement system understand how IP enforcement works in practice. I'm not only referring IP professionals, but all the enforcement authorities like judges, prosecutors, police, customs officials, market surveillance authorities, etc. And of course, the private sector actors. And you generalist lawyers, I think it is really important for you because we all know that from our data, we know that one of the first sources of advice that small and medium businesses turn on IP matters is their lawyer. So you've got to have a relative knowledge of IP in order to give them a better advice. By strengthening lawyers' knowledge of IP enforcement, we are indirectly but powerfully supporting SMEs in protecting their creativity and innovation. And as we all know, the prosperity of Europe's SMEs is essential to the continent's competitiveness, as they represent 99% of all businesses. The effectiveness of IP enforcement is also a signal of European strength and attractiveness and as a place to do businesses. In line with the Memorandum of Understanding we signed with the CCBE in 2023, we jointly developed a concise practical brochure on IP enforcement that was referred by Roman, and that will be explained by Jason later in the morning. It has been published in all EU languages, and it has been downloaded a lot of times. That reveals the importance and usefulness, and I really encourage you to download it after this webinar. I would like to extend my sincere thanks to the teams who made this webinar possible, and I'm especially grateful for our strong ongoing partnership with the CCBE and the ELF. I look forward to continue this fruitful collaboration in the future. Thank you for your attention. I wish you an insightful and productive session, and I encourage you to participate actively and to make the most of today's exchange. My team and I remain fully at your disposal. Thank you.
Thank you very much, Patricia. Thank you, Roman and Patricia, for your welcoming remarks. And we now move on to the first substantive session of the day. All our sessions are important, but for me, this holds a special place as one of the most important discussions of our age, which is, the topic is, enforcing copyright in the age of Gen AI, opting out content from use by AI systems, latest developments. Our speaker is Antoine Aubert from the EUIPO Observatory. He's an IP lawyer who has worked for the video game industry, the European Commission, and major global tech companies. He joined the EUIPO Observatory on infringements of IP rights in 2018, where he's leading the work on cooperation with intermediaries, as well as on the development of Gen AI from a copyright perspective. Antoine, over to you, please.
Good morning, and thanks for the introduction, Jonathan. Let me just share my screen. So, can you confirm you see my presentation well?
Yes, though it's not in full screen mode, it's in that other mode. You need to change your display setting, I think.
Now it should work.
Yes, that's it. Thank you, Antoine.
Sorry for that, and good morning to all, and thanks for the opportunity to present the work we've been doing in the field of copyright and GenAI. I think, as Jonathan said, the interplay between GenAI and copyright is one of the issues that is raising a lot of questions nowadays. Also, lots of lawsuits with lots of copyright owners that have been suing the AI company in general and GenAI company in particular for using their content or generating a content that is similar to their content. So with today's presentation, we just wanted to briefly run you through some of the main issues that are currently arising from the development of GenAI, and present the work we've been doing in the context of a study that was released in May 2025 on the development of GenAI, generative artificial intelligence, from a copyright perspective. This study has been conducted by the University of Torino, a team that was a mix of lawyers and AI engineers, and it has already been downloaded 25,000 times on our website, which for us shows the level of interest from all different kinds of lawyers, because this is a very legalistic technical study, and creators, to try and understand the issue, and again the interplay between copyright and generative artificial intelligence. Just in terms of what we were trying to achieve with this study, and that I'm going to explain, is there's lots of questioning from a technical point of view on how these generative artificial intelligence models are being trained, how they use content, and in particular copyright protected content that is available online. What is the applicable legal framework? What is the potential for development of a data licensing market? Is there a way for copyright owner to actually prevent the free use from their content by AI company and license it instead? And then looking to the solution that are developing to actually allow rights holder, copyright holder, to reserve their right from the use of their content by AI company, and the solutions that are developing in that respect. And I will go through that. So that's for the input side, what is getting into the GenAI system so that they can generate content. Now, there's the output side. We're normally referring to output as what is generated by AI system. And so, again, lots of questions that are technical, legal. How is the content actually generated? What is the applicable legal framework? Again, once more, is there a possibility for a licensing scheme to develop for content to be used as part of the content generation to be licensed? And again, some kind of analysis of the solution to identify and detect content that has been generated by AI. Now, just to run you through the legal framework when we're looking into copyright protected work and how they are being used by artificial intelligence system in general and a GenAI system in particular. Under the Copyright in the Digital Single Market Directive from 2018, there are 2 articles that are supporting text and data mining, and they decided that you can replicate and use content that is publicly available online for your own purpose. And so basically the CDSM directive is setting 2 exceptions. one under Article 3, that is a specific exception that is allowing text and data mining for the purpose of scientific research. So only research and cultural institution can benefit from this exception. And the CDSM directive is setting up under Article 4 a second exception that is a more general exception that is allowing text and data mining, but for any type of beneficiaries and use, so not limited to research and cultural institution. But there's a caveat that is copyright holder can actually opt out their work from the scope of this exception. So copyright holder can actually reserve their right and say that they do not want their content to be used for free under the exception and to be used under the scope of this copyright exception. So that's for the copyright legal framework. And then there's the Artificial Intelligence Act. That is a regulation that was adopted last year. That is not a regulation that is specific to copyright. That is a transversal regulation that is meant to address some of the risk raised by the development of artificial intelligence in general, but as a number of provisions that are relevant when it comes to copyright. One of these provisions is Article 53 of the Artificial Intelligence Act, AI Act, that is requiring provider of artificial intelligence model to provide transparency on input. So some level of transparency on the content they've been using to actually train their model. And so they need to make publicly available a sufficiently detailed summary of the data used for the training of their model. So this is highly relevant for copyright holders that are nowadays trying to find out if their content has already been used by AI model and what they can do about it. So that's for Article 53. The same article is providing for provider of AI model to have a policy that respects the European Union copyright law. And in particular, to identify and respect the reservation of rights from rights holder that do not want their content to be used under the text and data mining exception. So to some extent, this Article 53 is reinforcing the obligation for AI system provider to actually respect the reservation of right as expressed by rights holder. There's another article that is, again, this one is not specific on copyright, sorry for that. That is transparency on output. So obligation for AI provider to ensure that the content they are generating is marked in a machine readable way or is detectable as artificially generated or manipulated. So basically an obligation to make clear that your content has been altered or generated by AI so that user can actually recognize content that has been either altered or generated by AI. This is relevant when it comes to copyright because that will allow to kind of make a distinction between human created content and content that has been created with the assistance of generative artificial intelligence. Now, this regulatory framework means that legal rules have been set, but there's a number of technical mechanisms that need to be implemented by different type of player in the context of this regulatory framework. And that is fully mapped in the study, but basically you have copyright owner that need to implement measure to reserve their rights. And I will come back to that, but there's all different kind of solution and approach developing in that respect. There's AI company or company, well, a user of the text and data mining exception. Entity that want to claim that they are using content under the scope of the text and data mining exception, that have an obligation to respect this text and data mining opt-out measure or reservation mechanism. And then there's an obligation to implement a measure for AI company to make clear that the content they're generating and they're providing to a user has actually been either generated or altered through GenAI. So that's the regulatory framework and how it translates into some kind of obligation for the different player in the value chain. Now, some of the key findings of the study that we wanted to share with you today. There's been a narrative out there that access to content was needed to train generative artificial intelligence model, but that any given piece of content is limited to no value. And so there was this idea that AI system could be trained on any type of content, and that it was for copyright holder to tell the AI company which content they may or may not use, and that will not affect the quality of the AI system. Now, one of the findings of the study is actually that access to high quality content is central to the development of generative artificial intelligence model and services. And as we look into how these models are being developed, it may be true that at the very early stage of an AI development system, a given piece of value do not necessarily have like a high value. When it comes to refining the model for specific functionality, it may be that this model actually need access to high quality content to develop a good functionality. So if you're developing a model that is doing music editing, you do need access to music repertoire properly formatted to actually develop that kind of model. Now, on top of that, there's something that is developing that is called real augmented generation. And just to explain what it means, if you're searching nowadays on Google, you will realize that on top of the search result, you have these Vista search results that are coming up where an artificial intelligence system is actually gathering all different kind of piece of information to put them together and provide you an answer to a question. Now, for the development of that kind of services, access to high quality content is actually essential. If you think about news of the day, and if you ask a question about something that is extremely topical and news and related to the news, this model will need access to and do need access to high quality content. And so again, this idea that we're moving away from content as no value for the development of AI and copyright protected content as limited to no value for the development of AI to as this system develop and as new functionality and services develop, it is clear that access to high quality content is central. So this creates clear opportunity for a rights holder that have their content out there available online to actually license the use of their content for that purpose. But that can only happen if rights holder can effectively reserve their rights and opt out their content from free use under the text standard mining exception. So what we've been doing in the context of the study is that there's lots of practices that are currently developing to reserve the right, opt out the content from AI training. And the study is doing a full mapping of all the solutions that are currently being developed, from standard clause that are included in the terms of use of a given website to declaration from collecting society. And we've seen many European collecting society making public declaration saying that the entire repertoire that they are managing should actually not be used, to some specific list of music publishers that are saying that their repertoire cannot be used. And so what is described in the study mainly as legally driven approaches. But in parallel, you also have a number of technical solutions that are developing to facilitate reservation of rights through technical solution that can be machine readable, so that a AI system can actually identify as content or works they should not use as part of their training or as part of the material they will be using for generating content. And so you have a lot of technical standards developing, and there's lots of discussion currently. It's pretty complex for lawyers and for rights holders to understand how they can reserve their rights through this technical solution. You have some more advanced solutions that are where there's a repository of content that can be questioned to find out if the content has been so the rights on the content have been reserved or not. And you have some more advanced initiatives that are also developing where all kind of information is linked to a given piece of copyright protected content, and where reserving the right against the use by AI company is just one of the options that the rights holder can use. Now, in terms of all these mechanisms that are developing, and that's one of the findings of the study, there are many mechanisms that are developing, making the landscape pretty complex, with different solutions that have their respective advantage and limitation. No single observation mechanism has emerged as a sole standard right now, which is raising lots of questions from the content sector on which standard they should actually be using, or which solution they should actually be using to reserve their rights. But the truth is, there's also different standards that are developing because different content sectors have different issues and business needs. For the news sector, it's very important to protect the latest version of the article as it is on the news outlet website, and so to be able to make sure this latest version of the article is not being used. For the music sector, where the content, the music content appears on all different kinds of services, it's very important to make sure that this reservation of rights is expressed and can be communicated directly to AI company, as the content can be, as the content may appear on all different kinds of places on the internet. As part of the interview that were done in the context of the study, there was a call for an increased effort for standardization of solution, the flexibility to implement all different kinds of solution. So rights holder willing to be able to implement different solutions to meet their specific issue or business needs, but also to avoid excessive fragmentation. So having too many different standards that are developing. I will go faster through that, but the study is also looking into the solutions that are developing to identify content that is generated by AI. And there are many, as I said. It's going to be very important to have a solution that will be able to either identify content that has been generated by AI or detect it, to be able to make a distinction between what is generated by human and what has been generated either entirely by a machine or with the support of a machine. And so again, there's lots of solutions that are developing in that field, from AI company that want to make sure that they comply with this obligation under the Artificial Intelligence Act, that they need to provide transparency on the content that has been generated by their system or altered through their system, or from totally different services that are developing solutions that are facilitating the detection of AI generated content. Now, key finding on the study that includes possible role for public authority, and I will explain what we're currently working on right now. When it comes to GenAI input, so the content that is being used by a GenAI system to train, very important to inform on the copyright issue that are surrounding the deployment of generative artificial intelligence. inform on solution developing to reserve the rights. So solutions that are developing for copyright holder to make sure that their content is not used for free by AI company. And also the possibility for a public authority to help consolidating all the information on this reservation of right as they've been expressed by rights holder. Now, when it comes to output, and so this obligation for AI company to mark their content, important to inform GenAI developer and policymaker on the solutions that are developing, but also inform the general public on ethical prompt and usage. How do you use this new tool in a way that is compliant with copyright? I'll finish with this slide. I see that Jonathan is appearing. So just in terms of next step and what we're going to do, and that may be useful in the context of your work. So we have this study that has been published in May that is fully detailing all this issue. At the end of November, the EUIPO is going to launch what we call a copyright knowledge center. So we're currently aggregating all different kind of information we've been working on copyright, we will actually, and we are currently developing information resources to help lawyers and rights holders understand how they can reserve their right from free use by AI company. And I'll finish with that. We're also cooperating very closely with the European Commission that is looking at ways to identify all these solutions that are facilitating the reservation of rights by copyright holder. And so we're working with the European Commission in the context of the code of practice they're facilitating with AI model, and we'll continue to try and inform in the best possible way on legal and technical solutions that are supporting rights holder to reserve their right from free use from AI company. With that, Jonathan, I'm done.
Thank you, thank you. There are a few questions, and I think it's important we ask them. There's a general question, which was the first one, about the balance between the interests of society in developing AI and the interest in protection of authors' copyright. If we allow AI to use all this material freely, will this cause greater harm to authors than benefit all of society? And you're asked for your opinion. And I would just add another question I asked for your opinion. You've only spoken about opt-out systems. Have we completely given up on opt-in systems, which seem to be much fairer to people with copyrighted material? And I'll ask the second question from Anastasios Soulas, is whether you can provide relevant case law regarding infringement done by data mining so that the participants can study that. Now, you might not do that now, but I wonder if I could ask you, Antoine, if there are cases, if you could put them in the chat for everybody, that they could then study them afterwards. That would be helpful. There are further questions, but maybe if you answer those two as quickly as you can, and we'll see if we can ask any more. Thank you.
On the social benefits and the trade-off between protecting copyright and supporting the development of AI, again, I think this is one of the trade-offs that has been sought through the regulatory debate to come up with the not necessarily the copyright in the digital single market directive, because it's from 2018. And I think the text under mining exception was never meant to or envision use by AI company. But yeah, there is definitely a trade-off. And I think the regulatory framework that we have in Europe is actually one of the most advanced to try and reconcile the interest of rights holder on one side and AI development on the other. I think even when in the copyright holder community, there's still very different approaches with creators that are seeing GenAI as a fantastic tools in their hands that is going to lower the cost of production and things like that. and some rights holders that are pretty much seeing development of GenAI as something that is going to affect their activities and potentially their revenue. And that's where this approach of being able to reserve your right to make sure that your content is not used, again, not making judgment, is one of the approach. If we compare to what happened is in other part of the world, that has been doing a trade-off that is trying to reconcile the interest of rights holder and AI development. I forgot your second question, Jonathan.
The second question was if there are cases. Well, I asked about
Oh.
opt-in systems, but that's my question. You can ignore it. The question was about whether is case law that you can use on data mining that people could study afterwards.
I'm happy to share a few cases we do have. So there are lots of case law at international level that is developing, mainly in the US, on whether use of copyright protected content is fair use. We've seen a much more limited number of cases for the time being in Europe, but there are a few cases. And potentially also a referral to the European Court of Justice that I can, but that is still what is not even an opinion from an advocate general. But I think we are going to see case law development in that field, and I'm happy to share the few cases that we have in Europe right now.
Thank you, if you would. And there are two more. We need to move on. There are two more questions from Suella Sukia, whom you'll see that in the question and answer session. Most of it is around cease and desist letter templates. If there is a template that EUIPO has, or that you can refer to, maybe you'd put that in the chat as well. But maybe you could answer Suella's thing yourself. You can do that in writing in the question and answer box. But we should move on. Antoine, thank you so much. You see how much interest it generated. A very, very important topic for all of us for the future. But we should move on. And we move on now to our next session. And that is trade secrets, protection and infringement of trade secrets, civil and criminal enforcement measures. Our speaker is Erling Vestergaard, who's also from the EUIPO Observatory. He has been a Danish lawyer for more than 35 years, 21 of which he was serving as a Danish prosecutor. Since 2006, he's specialized in intellectual property and internet-related issues and has worked for EUIPO since 2014. Erling, over to you, please.
Thank you very much, Jonathan. Let me get the slides as quickly as possible, and we are off on this fascinating topic. It's one of my own personal favorite topics in intellectual property, and I've had the pleasure of working with a number of practical cases at the time when I was a prosecutor in Denmark, and some of my conclusions definitely comes a little bit from that experience. I'll cover three topics. What are we talking about and why is it important? Some typical situations of trade secret infringement and I have some practical case examples, well-documented case examples that illustrates the variety of trade secret infringement, and then which enforcement measures are available both in the civil and the criminal domain. And if there's time, a little bit of conclusion on the topic. Now, why is trade secret theft becoming such an important topic? There are many reasons for that. But the whole geopolitical situation we are in right now, with a shift in geopolitical interests, we have wars, we have undermining some countries, undermining the security of other countries. That makes certain sectors of society really sensitive. Defense, finance, telecommunication, semiconductor industries are not only industries that generate revenue that has an economic impact on society, but there's security interests in these sectors. So a loss of trade secrets can have serious consequences also for society. We see that we get much more tech-driven innovation now. And we see low-tech industries becoming high-tech industries because we see that these industries are integrating high-tech solutions. So if you were making refrigerators, there might not have been so much high-tech in that, but now the refrigerator becomes a computer. And all of a sudden, low-tech becomes high-tech. And we see the transitioning to green and more sustainable products. And again, that requires a lot of new innovation. So maybe companies weren't so innovative earlier, but now they need to rethink the whole line of production. They need to rethink their whole set of raw materials and all of that. Again, shifting the interest to trade secrets. And we see that a link to traditional counterfeiting of products and copyright piracy and attacks on patents and designs and development. We see that increasingly. And just an example, if you have a company that produces a high-tech product, the product itself might not be counterfeited so much, but there are spare parts. There might be thousands of spare parts in the line of production. And those are very interesting for counterfeiters to get into that market. And the easiest way to do that is to have an insider in the company providing sensitive information about those spare parts. I quote the Mario Draghi report here, everyone knows this, that we are challenged in Europe on our innovation. We need to be more innovative. And innovation starts with trade secrets. So what is a trade secret? Well, we are so lucky now that we have a common definition of trade secrets in Europe. It builds on the TRIPS Convention, as so much else does in intellectual property. But we have a definition now in the directive from 2016. It's a minimum minimum requirement directive, but the definition has to be uniformly applied. It means that a trade secret is information that holds actual or potential economic value because it is not generally known to others. That's the first requirement. The second requirement, it is valuable to others who are unable to lawfully access the information and is kept confidential through reasonable efforts by the trade secret owner. Here, I will make my first comment on the difference between criminal cases and civil cases. Civil cases have a tendency to, in a large extent, be focused on the last point. Was the information kept reasonably secret by the trade secret owner? This is less an issue in the criminal cases. In the criminal cases, it is more the question about identifying who is the perpetrator and the question about which trade secrets had been stolen. And this is a very general comment, and you will find that the opposite also applies. But as a general trend, you will see a lot of civil litigation where the problem of whether the information was kept reasonably secret by the trade secret owner is coming very much into focus. So what can be a trade secret? And this is where I'm always saying anything in a company can become a trade secret, and that's not true, of course. But it's really a wide area of information in a company that can be trade secret. Algorithms, source code, different software development techniques, computer programs under development. It can be business plans, strategies, pricing models, manufacturing process and methods, techniques, formulas, workflows. It can be databases, list of customer business partners, supply chain information, and it can be research and development data and designs, as I mentioned, or patents under development, pre-released artistic works, undisclosed photos, videos, and guidelines. I don't know if it's too far to come and say that every company disregardful of how big it is, has trade secrets. But even the local baker might have trade secrets, right? So I think it's fair to say that the vast majority of companies operating in the market, they have to some extent trade secret. Of course, I'm fully aware that the cutting edge tech companies, they have probably more valuable trade secrets. I'll have an example of that in one of my case examples. So what is the scope of protection, and what constitutes a trade secret in infringement? Well, as I said, the trade secret protection applies to confidential information that offers a competitive advantage. The protection is immediate. Of course, it's unregistered. That makes sense, right? If you had to make a trade secret publicly available in a publicly available registry, it wouldn't really be a trade secret anymore. And it's indefinite, as long as it's kept secret. This, of course, raises the question sometimes that is raised, do you go the patent way or do you keep the innovation as a trade secret? I don't think there is a conflict or there is really that dilemma, because many companies will operate both in the patent field and in trade secret field. And maybe the utilization of a patent will actually rely on specific knowledge that is trade secret protected. And it relies on reasonable security measures. It can be non-disclosure agreements, access controls, technical measures, technical security measures in IT equipment, and so on. But this is very, very important. And it helps the businesses avoid public disclosure and retain a competitive edge. An infringement occurs when a trade secret is acquired, used, or disclosed without authorization, and it includes physical theft, breach of the NDA, espionage, unauthorized sharing. Sometimes, we discuss reverse engineering, and that's generally outside the scope of trade secret theft. But there can be combinations, actually, when you both have a reverse engineering, but you combine it with a trade secret theft. That is also, these examples also exist. There's a lot of things going on in the EU and also in the EUIPO in regards to trade secret theft. It's become a lot in focus after we got the harmonization in the directive. We have published a couple of litigation reports. The latest one, just a couple of years back. There's a link here. You don't have to note it down. You get the PowerPoint and you can click the link. And that analyzes litigation trends and are some considerations about what happened after we had the directive, what has been the effect of the directive, and that's a very interesting report to have a look at. It covers both civil and criminal measures, so that's a very interesting one to look at. Trade secret theft is closely linked to other serious and organized criminal activities. And we have in Europe a system of law enforcement priorities called IMPACT, European Multidisciplinary Platform Against Criminal Threats. And that has a lot of trade secret thefts will fall under those priorities. First of all, we have an IP crime priority itself, but we also have a priority against cyber attacks. And that includes, to a wide extent, the attacks on companies with the aim of stealing trade secrets for different purposes. And you can see here, it's also identified in European Commission recommendation from 2024. This part. There is on the EUIPO webpage a toolkit to raise awareness of cyber theft for small and medium-sized enterprises. It is really a high-quality product, I have to say. It gives some hands-on, practical advice to SMEs to secure their data better. because every company in Europe it has the risk of being under attack for different reasons. And very often those attacks will focus on trade secrets because that is the most sensitive part of the company's IT infrastructure. So it's very important to secure data better and have a higher level of cybersecurity. And this is a very good toolkit that assists in that. We have in EUIPO developed for law enforcement and the judiciary, now both in Europe and internationally, a handbook on how to investigate. And we have added trade secret theft now this year because of the synergies with the other types of IP crime and because of the societal impact. Also because we see a significant rise in the number of criminal cases in this area. And I'll come back to a little bit some considerations about that. When an IP owner wants to make a criminal referral, they will usually apply one of the participants in the webinar here, their lawyer. And we have provided a guideline to how to make a good criminal referral. That covers trademark counterfeiting, copyright piracy, and trade secret theft. We have it available on the EUIPO webpage. And we have translated an FAQ and a checklist or checklists. We have translated them into all the EU languages. So there's a great resource here for the companies and for the lawyers that might not be accustomed to making criminal referrals with some hands-on practical advice on how to do that. I'll come back to the question, which do you go civil or do you go criminal if you want to go to court? I'll come back with some considerations about that. But if you want to go criminal, at least make the criminal referral as good as possible. And we hear it all over the world. The requests for training and capacity building on trade secret theft, it wasn't very much 10 years ago. I followed this area, as Jonathan said, in 2006. It wasn't a big issue at the time. There was still interest around it, but it wasn't a big issue. Now you hear it all over the world. It's repeated again and again that we want more capacity building and knowledge about trade secret theft. Now, I will come with 3, and actually not. I will come with 4, because there are 3 typical situations of trade secret infringement, trade secret theft. And then they overlap with each other. And there are examples. I'll come with an example where actually all 3 situations occur in the same case. The first is insider trade secret infringement. And that is current employees or trusted individuals. That could be different contractors, consultants, interns, business partners that are stealing trade secret. And they can do it on their own behalf or on behalf of a third party. They can steal trade secrets with the aim of just making income, getting paid for the trade secret right now, but they want to retain, to stay in the company. Or it can be that they know maybe they are going to leave the company. They might fear maybe being laid off. Or some other, and then they steal the trade secret, maybe without a concrete plan of what to do with it, but it might come in handy at a later point. So there are different situations here. But of course, it's very sensitive because there will be employees that have access, and that's a natural thing, have access to very, very sensitive information. And it could, as I mentioned, doesn't have to be employees. It can also be someone that provides services, cooperating with the company. We even have a case example where it was a person working for a government agency that was doing digitization of government services. And he was working so closely with cybersecurity company in regard to that he got so much insight into the trade secret that he was able to do that. So that just shows that even a public authority it can occur in. The insider will very often have a very trustworthy position. We even have an ongoing case, so I can't go into any major detail. We have an ongoing case where it was a person in a multinational company, and he was on top management level, a part of the top management of the company. So these are trusted persons, and they understand the value, and they understand the maybe where security is lacking in the company. We have a great case from Finland. We call it the shipyard case, a world-leading company in a certain specific types of ships. The insider has access. He steals very, very enormous amounts of data, very, very sensitive data, and he then gets employment in a company in another country, outside of Finland, and an independent expert valued the trade secret to $400 million. And the value was, what was the value for a competitor if they got access? It's not the loss, but this is the value of the trade secret. It was enormous. And the way he was found out was that he posted a photo on Facebook. He took a selfie, and you could see his computer screen behind it. On the computer screen, there was an icon, and that icon was a folder of data from the company. And when his former colleagues saw that, they saw, wow, this guy has stolen trade secrets. And he was posting, the post came from the competing company. And the case started. He unfortunately died before the prosecution, so that was only a fine for a company. Then sometimes the employee becomes a former employee. So you steal something with the aim, maybe it could come in handy a little later on. And that's very, very, very common thing that happens. Again, a person has this access, but somehow wants to leave the company, fears being laid off. There could be many other reasons, and then he steals it with the aim of utilizing the information later on. We have a great case here that we quote from the United States. It's about chemical formula in the food packaging sector, and there was a chemist there with access to the information, copied information to personal devices, and is later being found out, is being arrested in an airport, and on the devices is being found the confidential information. She was fined and got a suspended prison sentence. It's interesting to actually see that this was a relatively low sentence, but what we see a trend, I would say, if we look at the criminal cases, we see a trend that actually, if people are convicted, then the sanctions are relatively strong compared to traditional IP crime, like the counterfeiting and piracy. A trend that the sanctions are relatively strong. Not in this case, however. Again, by getting access to the devices, the clear evidence was found. There's a clear link between the data from the company and the data found in the defendant's possession. Hacking. This is an area where I would say there are almost no civil cases. And that is self-evidently why. Because hackers are very good at hiding their identity, and they can only be disclosed by, only is too far, that's too much to say only, but almost only by criminal investigation. And these are so organized, they are so good, they are so professional, these hackers that it takes a lot of effort to disclose them. Very often, these kinds of cases will not even be prosecuted as trade secret, because there might be higher sanctions for some of the other connected crimes, like the hacking, the cyber attack elements. I have my case example here, illustrates that very nicely. But that doesn't change that what the hacker is after is the trade secret, and it's the trade secret that triggers the case here. They're very skilled, they're getting better and better, and it is, I know from one country, I'm not naming the specific country, but that country considers hacking for trade secrets, including ransomware attacks, the biggest criminal threat against society, bigger than the threat of narcotics trade, because it's so sensitive. These are thousands of jobs on the line for the companies. I usually say, and again, it's a generalization, for traditional IP crime can be very devastating to companies, but they will rarely kill a company. But a very well executed trade secret that can effectively kill a company, or at least have enormous impact on the company's ability to be on the market in the long run, because the advantage goes to the competitor. So this is very, very sensitive. I'm not going to go into the techniques used for attacking trade secrets in companies. Read the toolbox. It's fantastic, and it explains all of these things here. My case comes from the US and the UK. It was a guy that was really, really good with the computer, and he was hacking into different accounts of famous musicians, and he got access to pre-released works. Very, very valuable. There's a whole infrastructure around this kind of thing. There are marketplaces where people are selling pre-released music, because people are so some fans are so obsessed with a specific musician that they're willing to almost pay anything to get their hands on a pre-released piece of music. So this was a very advanced investigation. There was a lot of preparatory work from the music industry, and they referred the case to law enforcement. That involved the investigation in the US and the UK. And they, at the end, are able to identify the defendant, including by way of crypto asset investigation. That's a means of investigation that's becoming more and more important, and definitely for trade secrets, due to the sensitive nature, and also due to the profiles of some of the people involved in this. Crypto assets is the preferred means of payment for trade secrets. But it opens up a lot of investigative opportunities, both for the private sector itself, because blockchain information is so publicly available, and there are so good tools to analyze it, but also for law enforcement, depending on under which type of rule the case is investigated. In this case, the charges were copyright infringement and the hacking offenses. It was not for the trade secret itself, but there's no doubt that sensitive trade secrets was involved in this case. He was given quite steep, he pled guilty and got 18 months of imprisonment and confiscation orders and the like. Very, very interesting case. And then I said you can combine all the three things with each other. And here we have a very recent case from Denmark. It's actually from, it's not more than a year old. It was a person working for a company, steals trade secrets, sends them out of the company via email. Not because the person knew what she was going to do with it, but they might come in handy later on. And then it's part of the stealing of that happened through what the court considered to be a hacking attack. So now we have an insider, we have a former employee, and we have the hacking attack in the same case. The case is found out because there's some security measures in place in the company that detected anomalies in these emails. This was not a normal way of using the company email system. And it's referred to law enforcement that does a very effective investigation. The person here is given a 1-year suspended prison sentence. And then again, you can say this is not such a high sanction, but if we compare this for how a copyright case would be deemed, or some trademark cases, you would see often lower sanctions for that. So this is for first-time offenders. Most trade secret offenders will be first-time offenders. So that's it is a sanction. We will also see we are seeing more cases coming up now with even stronger sanctions. But even here, it is quite a strong sanction. Here, a very good play together between the company, securing evidence, and having their corporate lawyer preparing the criminal referral, and quick action by the law enforcement authorities because they could see this was sensitive, and a very successful case was established. So what are the enforcement measures, and which kind of measure should be preferred? Well, one of the reasons why we got the directive was to make a level of harmonization in this field. We had already, for traditional IP infringement, a directive from 2004, but that didn't cover trade secrets. Actually, some countries implemented the directive in the way that it included trade secrets, but many countries didn't. And there are also specific problems and challenges in trade secret cases. And the directive deals with that. So basically, it is a complementary directive to the traditional intellectual property infringement or enforcement directive from 2004. One of the challenges that the directive deals with is how to keep confidentiality during legal proceedings. And that's the directive is for civil measures only. But the problem is the same for criminal measures. And one of the reasons why some companies do not take potentially good cases to court, either civil or criminal, is the fear that the confidentiality will not be upheld in the proceeding. A lack of trust maybe in certain legal systems, that even if they might have measures in place that in principle could protect the confidentiality, they might not have the trust that it will be implemented correctly or sufficiently. But the directive says that there should be measures in place, different kinds, of course, in accordance with the normal principles of that legal system. But there should be measures in place that ensures that the trade secrets being discussed in the legal proceeding is not being disclosed to the general public in the proceeding, and those measures shall continue after the proceeding is over. We know, like court proceedings are usually very transparent, and there's very good reasons for that, but this is one area where the information can be so sensitive that we need to make an exception to the general rule. The directive also deals with provisional measures, temporary stop, prohibitions of use, disclosure, bans of production, sale, import, or export of infringing goods produced by use of the trade secret, and seizure and surrender of suspected infringing goods. Very parallel to what we have in traditional IP cases. There are also measures on the merits when the case has come before the court, for the civil court, and there has been a decision. There can be injunctions, stop, prohibition of the use of the trade secret from as a permanent injunction, ban on production, sale, import, and export, and so on. When we're talking import and export, we know we in Europe also have border measures for IP infringing goods, like counterfeit goods and pirated goods, where the customs authorities can do interception of those and do action against them. But they don't cover trade secret theft, which it actually does in some countries. Some countries we will apply those border measures, also coming from TRIPS. They will apply them also for trade secret infringing goods. But we don't have that in Europe. So here you have to rely on the civil measures. And there can be corrective measures, recall of goods from the market, and so on. And of course, there can be compensation, damages. This is an interesting area because, as I mentioned before, from the Finnish case, the value of the trade secret was $400 million. That would not necessarily be the loss, because, and calculating the loss in a trade secret case is even more difficult than in a traditional IP crime case. It's really, really difficult to calculate the loss, and the loss might occur actually many, many years after that this happened. So this is an area where the calculation of the loss is very difficult, and the gain and the loss, even that in a traditional IP case, will not be equivalent to each other. But in trade secret cases, becomes even further away. So, and this is of course a big challenge for the civil lawyers to come up with a good, clear argument about how the loss was. But I think for the companies, very often what is interesting is not really to get the damages here, but is really to stop the bleeding, because that can undermine the company's ability to generate revenue for the future. Damages, as I mentioned here, publication of judicial decisions. It might happen in these cases. It's also taken from the enforcement directive for civil measures. I mentioned criminal measures, and I took now. It is because maybe you will call me lazy, but I took my own country. So these were the rules I worked with myself when I looked at cases. So, okay, yeah, well, that's the easy solution. So I took my own example here. There is no EU harmonization here, I have to say. The definition of trade secret, what is the scope of protection, what is an infringement, that is harmonized in the directive. But what is the criminal offense is not harmonized. And there's no obligation in TRIPS to have criminal measures. In Europe, there are criminal measures for trade secret theft in almost all countries. There are, to my knowledge, only 2 countries that have no direct criminal sanction. But there would be other provisions in law that could be applied. So it's not that it's not a criminal offense, but it's not directly a criminal offense as a trade secret theft. So we don't have harmonization, and generally speaking, the sanction levels foreseen in the legislation are lower than the sanction levels for other intellectual property crimes. But I think the reason for that is this is a younger crime. So, and there's a tendency when you get a young crime into the criminal legislation that the sanction level is not as high as for older crimes. But often the criminal cases will deal with very organized criminal activity. It could be the cybercriminality angle, and it will often be cases where if it's an insider or a former employee, if that person is very security aware, has a very high level of criminal intent, and is really knowing how to cover his tracks, that will very often be the criminal offense. And I would say that in general, when choosing which remedy to use, whether a civil or a criminal remedy, I think very often it will be whether criminal investigation is the only means of actually disclosing the full extent of the crime or even identifying the perpetrator. And very often be one of the key factors that play into that decision, because of course the criminal measures will very often be stronger. We have the criminal sanctions that will be felt quite deterrent on quite heavy on the defendant. But the downside for companies is also, to a certain extent, a loss of control of the case. So in that way, we see, well, it's a dilemma to take into consideration from the company which remedy to take. I have also myself had cases that began as a civil measure. So there was a civil collection of evidence, injunctions, as we saw before, but then it's referred to law enforcement based on that. That's also possible, but the downside of that is law enforcement works best if the defendant is unaware of the investigation. Because already here, it's the defendant has been targeted and knows he's being scrutinized. So the effectiveness of law enforcement response is less in a case that begins civil and goes to criminal. In some legal systems, that will even be very, very difficult to do. Some legal systems it's possible, but maybe less effective, actually. The Danish example here is it's quite high sanctions for small offenses, a fine up to 1.5 years imprisonment for the more serious one, and the very, very serious ones up to 6 years of imprisonment. And here is taking particularly the gain or the loss into consideration when deciding whether it is which of the categories we are in. Generally, my impression is that the number of cases is growing, and it's my impression that, and one of the reasons why we have done a lot of work on trade secret theft lately is to really come with some clear advice to law enforcement and the judiciary how to deal with these cases. One thing I would say for a criminal case, don't make it about the trade secret. Don't start a technical discussion in court about a technical solution for some very difficult to understand chemical or some very advanced thing. Make it about the data. And that's where criminal enforcement is strongest. It is the ability to analyze data, to secure data, analyze data. That's really the strength. So make it about analyze the trade secret data and analyze the data found in the defendant's possession. And make it about that. And not so much about the technical aspects of the trade secret, because there it would be very difficult. That will sometimes be the topic in the civil case. And that's also easier because here the lawyer representing the company will have direct access to all of the experts and all of the knowledge in the company and directly represent them, when a criminal procedure is a little bit different. So again, if a trade secret case comes down to some very technical comparisons between the products of the trade secret holder and the competitor, and there's a suspicion that the competitor has had access to these trade secrets, that will usually not be suited for a criminal procedure, much better for a civil procedure, because in the criminal procedure, there would not be the expertise around the technology that would be required. It would not be used. That is more for the cases where there's a clear evidential link between pieces of data. So a data crime, basically. And now I think, Jonathan, I'm doing pretty well. There might be some questions as well. So just a short recap. Trade secret theft is growing in importance, and it's not going away. It is really, really important. There are three main types. The insider might become a former employee. He hasn't started misusing the trade secrets yet, but begins when he's out of the company. And there's the hacking, and there is a few situations where you can combine the three with each other. They pose very different challenges, but they are equally they can be equally devastating to a company. We have civil and criminal enforcement measures. Civil measures inspired very much from the rules that we have in traditional IP crime, but also taking the sensitivity about the confidential business information shall be taken into consideration in the proceeding. And in the criminal measures, we are seeing more cases, but sometimes not prosecuted under trade secret crime itself, but maybe under cyber attack rules. And I think that will be it for me.
Perfect, perfect. There are some questions. Thank you very much, Erling, for your extremely clear presentation of very complicated matters. And maybe I'll start with a question which follows on when you were talking about the civil criminal procedure, because I hope I'm pronouncing the name correctly, Speller Grissar has asked really about abuse of civil court procedure, as I understand the question. Abuse of civil court procedure exploited so that the other side has to disclose a trade secret in order to win the case. So you're getting hold of the trade secret through a court procedure. Can you answer that one?
Yeah, that is definitely a concern that is being raised, and here I think it's really up to the court to make sure that the basis for taking action and doing some of these preliminary steps in the securing of evidences and doing these things is really vital. And here the companies have to be ready. They have to be ready to have a defense against these kinds of things. But I'm also aware that there can be sanctions against a company that might try to exploit the system and misuse the system. We also know it from traditional IP crimes, where sometimes severe damages are being awarded to a company that unjustly have been subject to such action. So it exists, and it's definitely a concern that it might happen. So it's up to the companies have the lawyer ready, right? If such an attack comes, and have the arguments ready as well.
Thank you. And Suela Sukcha has asked a few questions, but maybe I can summarize the essence of some of them, which is, could you speak about the trade secrets across borders outside the EU, either people outside the EU whose trade secrets have been stolen from within the EU, or people in the EU whose trade secrets have been stolen from outside, the cross-border elements?
This is the most common type of trade secret theft. It is the Finnish case was to a non-European country. I won't name the country, but you can guess in the back of your mind which country it was. This is the most common, because if you have a country with a great production capacity, but where they haven't reached the level of technical expertise that the European company has, they are willing to pay almost anything for those trade secrets. They are willing to pay gold for that, because they have the production facility and capability, and they can make it cheap, but they don't have the know-how to do it. So this is the most common type. Actually, very few cases. I have not very few, but there's a cross-border aspect in a lot of in a lot of cases. And we take the big companies. There might be 2 or 3 companies in the whole world that is even competing in that specific sector. So, and they will rarely be in the same country. So it's a very common phenomenon, and it doesn't make it easier. It absolutely does not make things easier. Also, the other example I had with the BPA, the case from the US, that was also on the airport. She was arrested in the airport on the way to that other third country. So it's very, very common phenomenon.
Sorry, I understand you to have been answering that this is if non-EU country or person steals from the EU. But what happens if it happens the other way? Do EU mechanisms assist people from outside the EU to pursue an EU?
Yes, absolutely. And the TRIPS agreement is very, very clear. We have to enforce IP rules the same way, no matter where the IP owner comes from, as long as it's the WTO country, which is almost any country in the world. So absolutely, our rules protect foreign companies that have been subject to trade secret theft and the trade secrets sold and misused in Europe. Our rules protect everyone the same way.
Erling, thank you very much indeed for your very clear answers. Thank you to participants for asking questions. We've come exactly on time now to our break. So we will have a coffee break. We've all had a huge amount of very useful information given to us. We can't keep going without a break. So there will now be a break of 10 minutes. And we will start again at 11:40 Central European time. Please do come back, because hugely interesting as this has been so far, there's much more very interesting material still to come. So we break for 10 minutes and we start again at 11:40 Central European time. See you all then, and thank you once again, Erling, for your excellent presentation. See you 10 minutes. Right. I calculated according to my computer that it is 11:40 Central European Time, so we begin again. And it's my pleasure to introduce our next speaker, who is Nicole Semyevsky, who will be speaking about the following topic: engaging customs in stopping fake goods, IP enforcement portal, IPEP, and filing applications for actions in IPEP, which are called AFA. Nicole is from the observatory at EUIPO. She's an IP enforcement expert from the observatory department, part of the IPEP team, where she's responsible for communication with users, user management, and training. She started working for EUIPO in 2000 and has been with the observatory since 2012. So, Nicole, over to you.
Thank you. Thank you for having me and for making room in your very interesting agenda for the IP enforcement portal. I will share my screen and start right to the topic. I have tried to shape the presentation a bit to the needs of the audience, which today is Leo representative. So it's my absolute pleasure to be speaking to you. Most of you have heard of the IP enforcement portal, or IPEP in short. For those of you who are not that familiar, it's not a new tool. It's a tool that it's now nearly 12 years old and has been developed by the EUIPO through the observatory to enable the exchange of information between rights holders on one hand and enforcement authorities. This was following a mandate that the office got when the observatory was established. And it's all about helping enforcers in the fight against IPR infringements. So right holders, they get an account in IPEP and they upload their product information, their IPR information, and most important of all, the contact information in the different member states. And then enforcers, they have a search bar and they can search, and they do keyword search, and they do it in their own language. So the tool works in 23 languages, so that when an enforcer does a search, he will find the information he's looking for, and he will be able to view it in his own language. It's a keyword search, so they can search for brand, company names, or types of products and get hits. And it searches in different databases. So it even if a right holder doesn't have an account in IPEP, at least they will have the right information from TMView and DesignView and GIView and see if there's a valid right they can enforce. And it's all about exchanging information. So right holders can send alerts to enforcement authorities and also file customs applications for action. We'll come to that in a minute, and receive notifications. It's all about exchanging intelligence in a secure way, in real time, and of course, free of charge. So this is IPEP in a nutshell. So right holders can provide information, send alerts, receive notifications. And what they can also do is they can make use of the information that is now in IPEP regarding the IP rights to help to get access or to get to the IP protection programs or services of the e-commerce marketplaces. Normally, you have to provide quite a lot of documentation proving that you're the right holder and that the rights are valid. So this can be done. This whole validation can be done also through IPEP, as we authenticate and validate everything. So that is IPEP in a nutshell. And the good news, and which was also a long time coming, the mobile app for our enforcers is out, meaning that all these searches and the first contact with the right holders to get some confirmation if something that was found is fake or not can be done on the ground. Enforcers have now access to IPEP on the ground. And this was announced in the IPEP summit last summer by our ED. And we're right now in the middle of starting the deployment to all these enforcement authorities. Today, we have 95 EU enforcement authorities accessing IPEP, so it's not bad. So let's focus on customs, and let's focus on the customs applications for action. I guess everybody in the audience is familiar with the applications for actions. If you want to enforce your IP rights at the EU border, you need to file a customs application for action. The AFAs. AFAs have a lifespan of 1 year. They need to be renewed because, of course, customs need to be updated regularly on what's going on with the products and with the IP rights of a given rights holder. And it can be union AFAs or national AFAs, depending on the rights that are included and the scope of action. If it's filed through IPEP, of course, we take care that the AFAs are generated in the language of the member states where they'll be applicable in. And of course, we also check that all the mandatory information that is requested from the customs regulation is inside. So we do a pre-admissibility check. So what is new, or what happened? AFA filing became digital. So since 3rd October of last year, it is mandatory to file the AFA requests electronically, be it the new AFA request or its renewal or any modification. And there are 3 portals that handle this. IPEP is the portal for 25 member states for filing and managing those AFAs, and coexist with the alternative systems of the German, the Spanish system for Spanish and German AFAs, or union AFAs that can also be filed there. So there is this 3 systems coexisting. What has been on the EFS have been installed. All this whole thing is fully functioning since December 2021. What is still missing, and what everybody is still asking for, is a digital signature. We are still working on it. The trick is here that the digital signature will be the same solution for the entire EU Commission landscape, so for all the DGs. IPEP is going to be the guinea pig, or is being the guinea pig. We will be the first place where it will be signed digitally with the signature that will be valid for all Commission requests. However, what I need to insist here is that for the time being, it is mandatory to file the AFA request, any AFA request electronically, but the signature is not yet. So we're not yet there. We still sign the request manually. Some member states, they have their own national digital system. So once the PDF is printed of the request from IPEP, they can be also signed using the national system. But through IPEP, for the time being, still not working, we still sign manually, okay? Basically, once the AFA request is sent, it's printed out, signed, and sent in paper form, signed to customs. Now, very basic for those of you who are not yet familiar with IPEP, how to access. We have over 2,500 brand holders, right holders now in IPEP. So very often your client will already have an account in IPEP. So our suggestion is always, if you have a client, contact the IPEP team at our usual address and check in if the client already has an account in IPEP. Because in such a case, the legal representative just needs to be appointed, okay? He can be appointed within the account by the rights holder or the master user, or we can reach out to the right holder and ask them to permission to give the legal representative access. Should the client not have an account in IPEP, of course, the legal representative can request the account on his behalf. There are 2 ways of accessing IPEP. The normal, usual way is through IPEP credentials, which we give. There is also the possibility to access through the UMDS credentials, which are the credentials that are used by DG Taxud, by the traders portal. So if somebody has these credentials, they can use them also to access IPEP. But I think of the 2,500 companies we have, I think we have 9 companies accessing, or 9 users accessing with these credentials. So it's really an exception. But for you to know, there is this option. So how do you access to IPEP? we have an authentication protocol which involves the rights holder. We know that legal representatives are not very happy with that, but we need to involve the right holder in giving access to their account. So the way we do is if the right holder has designs or trademarks, we usually ask for a trademark number. We then go to the register and look what is the registered address of that trademark and who's the registered owner. And we send a letter per courier service to the right holder with a safety code. And whoever gives us a safety code back becomes the master user or the main contact person for that right holder. Now, legal representatives are always appointed through their clients' accounts. So if it's a legal representative that sends us back the safety code because a client has handed it over, well, they become the master user, they access the account, and they appoint themselves as legal representatives, okay? But it's always through the client's accounts. Now, we have some good news for the IP community. We have agreed now that the safety code letter, we can also, instead of sending it to the right holder per courier service, we can also send it to the right holder per email to speed up things. Now, if the email address of the IP owner is registered in the EUIPO user area, then we are ready to send the safety code instead of courier service also per email to the right holder. Okay, so just for you, this is new. This has just been decided now after summer. So alternative to the letter by courier service, enter the email address of the IP owner in the owner information of the user area, and then we can also send the safety code letter there. Should the right holder own other types of right, like plant variety or patents, then of course you can send us also the registration number to the IPEP team. We can also give access on that grounds. Or if it's a geographic indication owner, absolutely no problems. They can request the access through GI View. And should the right holder have no own rights, be a licensee or a copyright owner, which is a right that is not registered, then we always ask for the EORI number. It's also a way of having a related address and being able to send the safety code letter somewhere. Again, I stress the need to involve the rights holders. You have to imagine you have national AFAs in 27 member states. It's very often that the right holder, a brand, has 27 legal representatives in 27 member states. It's not rare. Somebody needs to overview who accesses IPEP, who is the master user, who has the control. So, I mean, there is no way around involving some central person who has an overview of the IPEP account and sees who has access and who has to get access, okay? So we have analyzed this numerous times, but we still stick to the idea that we need to involve the rights holder. Very shortly, and with this I finish, there's also the issue of the ex officio AFAs. You know that when customs detain goods and there is no AFA in place, a right holder are giving 4 days to file an ex officio AFA. Now, 4 days is a very short time, especially if you still need to register an IPEP to be able to file such an ex officio AFA. If you receive a request to file an ex officio AFA on behalf of your client, contact the IPEP team. We give you immediate provisional access. You can request the access. You give us you mentioned that it's an ex officio. You give us a reference number of the detention notification. We give immediate access, and then once the ex officio is filed, we deactivate the access, and once the authentication procedure is finalized, then we give access again. But the authentication procedure should not be an impediment for somebody to file an ex officio AFA. So this is very important. On the IPEP landing page, you find a lot of information on helpful information, and you find also help files that explain you how to do things, also for the ex officio. And what we also do is we have monthly demos and question and answer sessions. Normally it's always the last week of the month, where we do a walkthrough through the tool, and it's followed by questions and answers. Everybody can join in. You just join the call. You don't even need to register. And we do one-to-one sessions. We help you where we can. So you have our email address there. But any questions you have, the IPEP team is there to help, and we assist you with all the questions you have. And now I stop because there may be room for some questions. Thank you, Jonathan, for bearing with me.
No, Nicole, thank you. Very clear presentation and on a very interesting subject. Just a question for you, which is, once the legal representative's account has been created through the IPEP account of a right holder, what's the procedure for creating an account for another right holder?
Thank you for that question. Yes, absolutely. At the end, what we do is we link users. So when the legal representative gets his user access to one account, when he's appointed next, the account is linked to the user. So when they link in with their users, they see all their clients' accounts and they can then jump from account to account. It's like they would have a representative account. So they don't need to keep credentials for different clients. They just go. So the procedure is always the same. They always need to request through the procedure. But once they get appointed, the account is linked to the user and they can then work in all the different accounts.
So if I've got a client who's a licensee and doesn't own the IP rights, can you explain again how to request an IPEP account in this scenario?
Yes. I have not spoken a lot about the EURI number, but you might be familiar with the EURI number. The EURI number is a tax registration number that's valid in the entire EU. And if you want to file an AFA, you need an EURI number, both for the right holder and the legal representative. Now, this EURI number is also linked to an address. So we have taken advantage of that and saying, okay, if you have a licensee who doesn't own a right, we need also, again, to have somewhere to send the safety code letter. So what we do is we take the address from the EURI number. So in such a case, be it a licensee or a copyright owner who wants to file an AFA, the easiest thing is to send us the EURI number, and then we will send the safety code to the related address. Thank you.
Very good, very good. I have no more questions. I see no more questions. So on that, Nicole, thank you. Very clear. As somebody's put in the chat, thank you. Very practical. So that's exactly what we needed. So thank you very much, Nicole. And we will.
You're welcome. Thank you for having me, and good luck with the rest of the webinar. Thank you.
Thank you. We move on now to our next session, which is Christian Toth from EUIPO Legal Affairs Department. The topic is anti-scam, misleading invoices targeting IP right owners. Before joining EUIPO almost 10 years ago, Christian gained extensive experience at the European Commission, at EU agencies and national ministries. He's a team leader in the Legal Affairs Department at EUIPO, and his team, which is called Protect, is dedicated to covering legal matters concerning various rights that EUIPO needs to protect and enforce. One of the key areas they focus on is the policy against scams involving misleading payment requests to users of IP systems. And I think that's what we're about to hear from now. So Christian, please, over to you.
Thank you very much, Jonathan, and good morning, everyone.
You just need to make them full screen and then we're there.
Yeah.
That's it.
Here you go. So good morning, everyone. It's a pleasure to be here today to talk about misleading invoices and other types of payment requests targeting IP right owners. First, let me summarize some key characteristics of the misleading payment requests. These are seemingly realistic letters or emails that demand payment from IP system users. For what actually? Either for unsolicited or entirely fictitious services. In some cases, to obtain or maintain registrations in unofficial or completely fictitious databases. We are also facing fake emails that seem to come from the EUIPO or another IP office. The recent methods we have observed are payment reminders with imitated EUIPO logo and, unfortunately, sometimes with names of genuine officials of the office. Some scammers decide to use even letters with QR codes to mislead the recipients. What is the impact of misleading payment requests? In 2024, Europol prepared a situation report, which is also accessible on the EUIPO website, so I would like to advise you to check it out. And they calculated with more or less 1% of EU trademark owners falling victim to scam. The basis for their calculation was that we might have 17,500 victims, and with an average invoice of 1,500 euros, there might be a yearly profit of around 26 million euros. This clearly impacts the reputation of the EUIPO and national IP offices, and it affects the users, as they may lose money and might lose their IP right in extreme cases. Well, when can users be targeted by a scammer? On this slide, you can see the entire IP protection period. The first vulnerable moment during the IP protection period is of the trademark or design applied for. Then we have a second moment, which is shortly before the end of the opposition period. Going a bit further in the timeline, you will see that the publication of the registered IP right is another moment. So shortly after that moment, users might receive misleading payment requests. And even some weeks later, this is point 4 in that scheme. The fifth vulnerable moment that we have identified is shortly before the start of the renewal period. Well, what is the EUIPO doing in this area? Let me briefly summarize the EUIPO's anti-scam activities. First, we established the anti-scam network that brings together representatives from national and regional IP offices. They come from EU member states and EFTA countries. We have the European Patent Office, the World Intellectual Property Organization, Europol, Eurojust, IP offices of candidate countries working with us, and certainly we also have several user associations. We coordinate these activities against the senders of fraudulent payment requests. The EUIPO also provides support to users who received misleading payment requests. The 4 pillars of our policy in this area are legal actions in certain cases, then IT security measures, we use lots of communication activities, and we also cooperate with several stakeholders. There were 2 recent successful criminal cases in Georgia and Germany, where the defendants were found guilty of fraud by the court. I will briefly touch upon these 2 cases. The EUIPO also notified numerous banks about the suspected illegal scam activity of the clients, and we are also considering further actions based on fraud and also criminal trademark infringement. This is because the EUIPO's name, acronym, and logo are registered EU trademarks. Let's speak a little bit about the German case, which is the European IP Register UG case. As to the background of this case, back in December 2020, following numerous reports from customers, the EUIPO filed a criminal complaint for suspected fraud before the competent public prosecutor's office in Germany. The fraud scheme consisted of letters sent under the name IP Register UG. You can see on the screen a sample of this misleading invoice. As you can see, the letterhead featured the designation European IP Register, and then the subject line highlighted data publication from the Office for Harmonization in the Internal Market, in brackets, OHIM. This was actually the old name of the office. The misleading letters included always a total due amount, a payment deadline, and bank details. And only in a small print, barely legibly, was the invoice characterized as an offer. Finally, in September 2024, the Munich court found 3 defendants guilty of commercial gang fraud. Each defendant was sentenced to 1 year and 10 months of imprisonment, which was suspended for a 3-year probation period by the court. Importantly, the court ordered the confiscation of around 200,000 euros, which was available to compensate the victims. The EUIPO considers that this is a really important precedent for us, because a criminal court of an EU member state has qualified the sending of misleading payment requests to IP system users as a criminal offense of fraud. Moving to the next case, we have a case which was recently closed in Georgia. This case started following the notification to the Financial Monitoring Service of Georgia in 2020. It's part of the facts of the case that the perpetrator established a company which was called EIPA, Intellectual Property Agency, as a Georgian LLC. You can see the misleading invoice there, so with the name EIPA, which is confusingly similar to the name of the EUIPO, and you can also see the colors blue and yellow, which are similar to those applied in our logo. The damage that was caused was altogether 76,900 euros in total to 31 victims. Following the criminal proceedings, there was a plea bargain with the prosecutor, which was approved by the court in December 2023. And the court found the defendant guilty of fraud and money laundering under Georgian law. The indicted person was ultimately sentenced to 3 years of imprisonment, which was suspended by the court. I would like to show you some recent examples of fake email samples. Here you can see an example which seems to originate from the executive director of the EUIPO. The individual that sent out this misleading email refers to TMView, which is managed by the office, but this is actually a search tool for which the IP right holder doesn't need to pay anything. So it's actually completely false when they state that failure to pay the fee may result in the loss of the rights associated with your community trademark application. This is an invalid statement. We found also fake trademark registration certificates in attachment of certain emails. This is a clear example for this, where you can see the name of the deputy executive director of the office. His name is actually indicated as the executive director, and the signature is completely fabricated. You might also ask us whether scammers make use of the emerging use of generative AI, whether it increases the opportunities for scammers. And our answer is yes. We have identified certain areas. For instance, data mining for victim identification, because AI allows scammers to identify and collect email addresses of IP right holders. They then exploit these email addresses to send unsolicited and deceptive communications to our users. The use of AI to generate documents in multiple languages is also a danger in this case, because AI allows scammers to create highly convincing fraudulent invoices in several languages. And this complicates the recipient's ability to detect misleading information. The third example that I'd like to mention is machine learning pattern detection. There are certain algorithms which may analyze payment patterns, and they predict when businesses are most likely to process invoices. Of course, this gives scammers certain possibilities to strategically time their attacks for maximum impact. As a response to all these challenges, the EUIPO prepared a simple leaflet, which you can find on the EUIPO website, along with warnings, information, misleading invoice samples, and this leaflet is available in 23 EU official languages. It gives basic information about misleading invoices, indicates the warning signs, and also what users should do if they receive a misleading communication. Importantly, it includes 2 bank accounts, and these are the only genuine bank accounts that the EUIPO holds. So in simple terms, if the scammer requests payment to any other bank account, it doesn't come from us, so no payment should be made. Finally, I would like to convey certain key messages to users based on our observations. We would like to encourage users to report scams to the police. This is really important because the more reports are made to the police, the better visible is the extent of this phenomenon. They would like to advise users to retain evidence in all those cases, and also to provide the scam email with its header to the EUIPO for further investigation. Finally, they would like to remind users to continue to compile evidence for legal action where this is appropriate. And this brings me to the end of my presentation. Thank you very much for your attention, and I'm available for any question that you might have.
Thank you very much indeed, Christian, for that very clear presentation and for keeping so well to your time. I assume that misleading emails are increasing to IP system users compared to the old days of paper invoices. What steps should users take if they receive such an email?
Thank you for the question. It's really important that they keep these emails in their entirety and send them to us, report them to us, or to any national IP office if the application concerns a national application. Send it in its entirety. Why? Because it's the email header that can be investigated from an IT forensic point of view. The EUIPO closely cooperates with Europol as well, based on a service level agreement. And if we have the entire email, not only as a forward, it allows us to follow the appropriate paths, to send it to Europol, and they may operationally support investigations at national level and provide the relevant criminal analysis.
Wonderful. Thank you. Thank you very much indeed. There are no further questions, so we'll move on to Yasin. Yasin very kindly had shrunk his time when we were preparing the program, so now you have more time, Yasin, to tell us about an extremely important document which we have been hearing about throughout this session, which is the EUIPO brochure on IP enforcement for generalist lawyers in the EU. Yasin comes from the observatory at EUIPO. He's a seconded national expert from Bulgaria and part of the EUIPO's observatory outreach and knowledge of IP service. He works on various initiatives for SMEs, small and medium-sized enterprises, and the implementation of the Memorandum of Understanding with the CCBE. So, Yasin, over to you, please.
Thank you, Jonathan. And of course, a big thank you to all the participants that we have with us today. I hope that the agenda is interesting to you. And of course, we will follow up with all information and presentations later on. Allow me just to share my screen. So if you could confirm that you can see it well.
Sorry, I was on mute. Yes, we can. Thank you.
Okay, perfect. So let's go on. So you heard about the brochure already mentioned in the opening remarks, but just to give you a little bit of overview what it is about and how you can use it in your daily work. So first of all, it's very important, of course, to mention that this is a joint brochure developed together with the CCBE. And as mentioned by the first vice president, we also have consulted national members of the CCBE in its production, especially on the different language versions. We have the brochure in all EU languages, 23 languages. And on top of this, we also prepared a printable booklet version of the brochure, which you can easily print out and keep somewhere at hand on your desk. So whenever IP comes as a topic in your discussions with your clients, you can have it ready there and see what are the next steps possible for your clients and where you could guide them to. The idea of this brochure, of course, the context is our work that we do with small and medium enterprises. Already 4 years and maybe even longer, we've been focusing on helping them understand and protect their IP as part of our previously so-called Ideas Powered for Business program and our SME fund. So this is really one of the efforts to help SMEs also through the generalist lawyer, who is very often the first point where SMEs turn for help. The brochure is quite simple and easy. It has different sections. So in the first section, we explain, of course, what is IP, and we especially highlight why IP enforcement is important for your client. Of course, here we mention the protection, strengthening of the company's reputation, and of course, a very important topic, monetization of IP. So the point that companies can sell, license, and franchise their IP, as well as the attractiveness of IP towards investors. So using IP as a collateral, for example, to get a credit from a bank or other financial institutions. Then we explain as well what IP owners can do using, selling, and of course protecting their IP. And we also provide definitions of counterfeiting and piracy. Of course, when the scale of the infringement is bigger, it's important to distinguish between these terms and to name the problems with the right names, of course. And then one of the main parts, so to say, of the brochure is the explanation of each of the relevant IP rights. So we talk not only about all the main IP rights, the trademarks, patents, designs, GIs, and copyright, but we also talk about domain names, for example, and trade secrets as well, what was also in focus of the presentation of early on. So you have here, for easiness, the term of validity, the geographical scope, and where the respective right should be registered or not. And another key part are the two scenarios in which your clients might find themselves in. So first, the scenario your client as a claimant. So for example, he or she has evidence or suspicion that someone has infringed their IP. So there we look at different scenarios, different situations, and of course suggest possible next steps. So in case of in case of the different situation, of course, you can relate them to consult, for example, a specialized in IP lawyer to start civil proceedings, for example. And if there are counterfeiting and piracy activities involved, you can advise your client to think about also criminal or administrative proceedings. And then in the case where your client is a defendant, so for example, they were accused of infringing the IP of another person or company, that also, again, you have the possible next steps for your client as a defendant, which could be useful in the various situations. A topic which, of course, was touched upon quite a bit in Antoine's presentation earlier. So the new technologies, AI, all these things, we have some general advice on these issues: social media, e-commerce platforms, mobile apps, and generative AI. But of course, I think these topics, as the brochure was launched last year, I think these topics you have to develop furthermore in the future. So let's see what can be done in this regard. But there is a section related to this as well in the brochure. And finally, I think the most important part, the useful links where you can find all the information, also everything which was mentioned today from our side, but also from the CCBE. So you have the website of the EUIPO, of the CCBE, IPEP, what Nikki presented earlier as well. And of course, partner organizations such as the European Patent Office, the World Intellectual Property Organization, etc. So you can download the brochure just scanning the QR code which you see on your screen. Right now, I'll send you also the link once more in the chat. So we have already over 2,000 downloads, and hopefully after today there will be more. And I really hope that you find the brochure useful, and any recommendations, advice on it, please send to us, and we will of course consider it. Thank you very much.
Thank you, Yasin. I have a question for you, but I wonder if Christian could come back online, because we had a question for him also,
Okay.
just as his session was ending. For you, can you just tell us how many languages the brochure is available in, and whether it's going to be updated? And whilst you're about to answer that, I'll ask also Christian the question which has come in for him, which is, would it not be wiser to find first from where the scammers are finding the data of the users to contact them after they've submitted the trademark application? But Yasin, you go first, and then Christian can reply.
Yes, so the brochure is available in all EU languages. We only don't have Gaelic. So all other 23 languages you can find on the link which I just shared in the chat. And on the update, yes, we have to, this is something to be discussed, of course, with the CCB, but I see definitely room for update, especially when it comes to new technologies, as the development there are quite rapid, and we might need to reflect on this. Thank you.
Thank you, Yasin. Thank you for your very clear presentation. Christian, the answer to your question.
Yes, the answer to this question is the following. The difficulty we are facing is that the EUIPO is under a legal obligation to publish certain data regarding the trademarks and designs that have been applied for. And this includes the name of the applicant in all those cases. Even if the scammers cannot find the email address of the applicant among the published data, only the address, but it's very easy for them to identify any email address, in particular functional email address linked to the applicant, because they may use publicly available internet sources. So in the past, we had basically paper-based communication, letters sent to the applicant, because they could identify the postal address direct, but nowadays, emails. So this is a strong indication that AI may also be used, because using generative AI is very easy to identify any useful email address for any applicant.
Indeed, indeed. Thank you, Christian. Thank you for coming back to answer that.